Welcome back, everybody, to You're Free to Go. I know it's your favorite podcast, so please remember to follow, like, and subscribe. Really, really important. We're getting a lot of traction out there in the world Wide Web with podcasting on YouTube and Spotify and everywhere else. So please continue to follow us, like, and subscribe. It is free, and it's just allows us to get our message out to the entire world. And so we're excited to be back today. In our last episode, we started it with a question from one of our fans, and we got a lot of positive feedback from it, Mark. So we're going to do another episode where we start by answering one of our fans' questions. And it's actually no surprise to me that a lot of people come to me and say, well, how do criminal defense lawyers bill? Like, how do you charge a client? How do you decide what to charge them? Like, I've had a divorce lawyer, I've had a corporate lawyer, I've had a car accident lawyer, but I've never had criminal. So how does that work? So I thought maybe, we'll kind of address that because this podcast is entertaining, but it's also somewhat educational.
Well, we've got some entertaining vignettes to talk about.
Agree.
With respect to that. Well,
Yeah.
I can answer for me, and especially in federal court, I don't generally charge by the hour. I mean, most lawyers in civil cases, except for accident cases, charge by the hour, hourly billing. You get paid for the time you spend.
Right. Yeah, let me just be real specific on that. It's a fee structure called contingency fee. So if someone gets injured in a case.
You mean an accident case?
Right, an accident case. You get injured, could be a slip and fall, could be a car accident. The lawyer will say, I'll represent you on a contingency fee. This may be some too much minutia, but it's just to share with the audience education on how that lawyer doesn't get paid a penny. If they work on the case for 5 years and they lose, you don't owe that lawyer a penny. But if they win, traditionally around the country, it's typically they get 33 1/3% of what they win.
I've seen mostly 40% if they go to court.
Right. The moment they file the lawsuit, it goes from 33 1/3 to 40%. Right. So that means if you get $100,000, but they actually had to file the lawsuit, the lawyer gets $40,000.
And then, of course, costs.
Right.
The lawyer's advance come off the top.
Right. So it's a $100,000 settlement. Let's say there was a $10,000 doctor bill that comes out. Now you're at $90,000. But the good news is the client has access to the court system without having to go in their pocket or pay anything. The second most common way that we see billing is hourly. So let's say a lawyer working on your estate planning or your corporate, business law issues, you bill them. They may say, I'm worth $700 an hour, and this month I spent 6 hours on your case, so it's $700 an hour times six hours that month.
And usually lawyers have money in trust and retainer to bill against rather than chasing after.
Right, so the client has to put money in the retainer as a deposit, and they work that down, and then when it gets close to zero, they say, hey, you got to put more money in. And what's interesting about that is you don't know what you're getting into financially as a client. The first month, you say, oh, it was 6 hours times the $700 an hour. Next month, there was a huge hearing. There was 21 hours that month, and the next month, maybe nothing, 2 hours. And you look back after a year, and you say, boy, each month, it adds up. I just spent $40,000, right? So you have no idea until the case is over what it's really going to cost you. So those are the two common ways. And then as you started to say, what's the common way for criminal, it's different than those two. So I'm sorry I cut you off. But
no, criminal case usually take a flat fee. Hourly billing, I do hourly billing on clients before they're charged in pre-indictment representation, because I don't know how long that's going to go on for. I don't know whether it's going to result in me talking the government out of indicting my client or we work out a plea. But once someone is charged with a crime, almost invariably we charge hourly.
Right.
Problem in federal court is that once you sign on as an attorney in federal court, and this is pretty much universal throughout the country, once you sign on as the attorney, enter your notice of appearance, you can't withdraw because your client hasn't paid you.
No.
Which is why we need to get all our money up front.
Right. Which clients are often saying, wait, I have to pay you up front.
And they say, I'll pay you a little now and a little later and a little later. And I always say to my clients, look, I believe, and often I do, I believe that you intend to pay me,
Right, yeah.
that it's a good faith effort on your part will be made to pay me. The problem is anything can happen.
Your roof could have a major leak that costs $100,000 to repair, right?
Something could happen that
Yeah.
affects your ability to pay.
Correct.
And then I'm stuck handling this major case and not getting compensated for my time and my effort.
Right.
Now, when clients don't pay on purpose, that's why I always get the money up front. But, in the past, when I was younger and a little bit more foolish and not as business savvy, I would trust that they would pay me. And a lot of times I got beat.
Yeah.
And there was a famous lawyer in Miami, I remember, saying once to his client, if you don't pay me, you'll have my body, but you won't have my enthusiasm.
All right.
But the truth is, we are bound by our rules of professional responsibility and also our sense of fairness and justice and our moral compass to do the best we can for our client, no matter whether they've paid us sufficiently or not. I don't want to be in that situation.
Correct. I was in that situation once. It's been a while. It was earlier on in my career, but it was basically a Ponzi scheme. And I was paid a six-figure fee, and there was a trial fee kicker if it went to trial. I didn't get the trial fee up front and put it in my trust account like I should have. I learned from this case to always get the money and put it in the trust account. If you don't go to trial, I give it back to them. If you do go to trial, it's earned. So in this case, the trial fee was going to be $80,000. And we're at the day before trial. Very often it's called a calendar call, and the judge says, okay, you'll pick your jury tomorrow morning, 9 a.m. So we're at that calendar call, and I knew the prosecutor pretty well, and they could tell that something was going on. And what was going on was that this client was stiffing me on the 80 grand. They were street smart, and they knew I couldn't withdraw from the case. So they were just going to, which is really kind of short-sighted on their part. You don't want your lawyer who's fighting for your freedom to not be happy with you and to think, oh, my own client's ripping me off, and now I'm supposed to go fight for their freedom. So it's not the smartest thing for a client to do. And he had the money. He just thought he would outsmart me, that he knew the judge wouldn't let me off the case. But I was doing some things in my conversations with the prosecutor. Of course, it was attorney-client privilege. I wouldn't tell the prosecutor that my client was stiffing me the $80,000 trial fee. But the prosecutor said, come on outside for a minute into the hallway of the courthouse. He said, Guy, would it help you if I null pros, which means dismiss, no prosecute, it's a Latin term, the case today and refile it? I said, what's your theory on that? He said, well, we thought it was about a $22 million Ponzi scheme here, but based on all of your discovery you've done through depositions and your motions, I think it's more like an $8,000 Ponzi scheme. So I think in good faith, I could dismiss today's case and refile tomorrow morning with new charges, reducing the amount of theft here. And would that help you? And I said, yes, it would help me a lot. So for those listeners who don't realize this, the moment that case gets dismissed, my representation is officially over, concluded. So we go back in the courtroom. He's like, my client says, what do you want? What do you want? Because it's very rare, like right when you're about to start a hearing, that the prosecutor asks for a private conversation. I said, I got good news and bad news. So the good news is they're lowering the amount of theft substantially. That's great, your exposure is much less and so forth. He's like, well, what's the bad news? I said, well, I'm officially, in the next minute, I'm no longer your lawyer. Yeah, so the prosecutor came in, judge, we're null prosing this case. We're going to refile in the morning, reducing, the restitution and so forth. And then, of course, this client was begging me, come back. And I said, nope. He's like, I'll double it. I'll give you $160,000. I said, no.
In state court, a lot of times lawyers are allowed to withdraw.
Yeah.
Even because they haven't been paid. And I remember back when I was a DA in Brooklyn, New York, and lawyers would have a certain code. It took me a while to catch on what it was, but they would go in front of a judge, and the judge would say, are you ready for trial? And they'd say, not yet, Your Honor. We have a missing witness. Mm-hmm. And who is that missing witness? Mr. Green.
Yes, yeah.
With Mr. Green, the missing witness, and the judge understood what that
Right.
meant. You hadn't been paid fully yet. I'll keep this case going till you get fully
Right.
paid.
And I think the great, criminal novelist John Grisham pulled that into one of his novels
Oh,
once.
maybe.
Yeah, I forget which actor went before. McConaughey, I think it was Matthew McConaughey went to court one day and said, "I'm looking for Mr.
Mr.
Green,"
Green,
and he
yeah.
got the continuance.
But the interesting thing about it is that let's be frank, trying a criminal case in federal court is very expensive.
Yes, yeah,
Rarely is it less than $100,000.
Right.
And I've had trials that I've had 2 4-month trials.
Right.
So you can imagine what the cost in that. Not to mention, a lot of my cases are out of town, so I have to be put up. I had a case in New York where I actually took an apartment. Pretty much lived in New York for a year. Of course, my clients at the time, their family were billionaires.
yeah.
So it made a big difference. But it's very expensive. And of course, when you're in a long trial, even if you're well paid for your time, there's a negative consequence. You're out of commission. Like, for example, 4 months, you're
Right.
out of commission. You really can't do anything else. When you're in trial in a criminal case, you live, you eat, and you breathe that case 24 hours
True.
a day.
That's true.
And other clients that you have, they want your attention. Things are going on. You lose the opportunity to pick up new business.
Right.
So there is a cost factor to that to you.
And I tell the clients that are like trying to reach you, I say, well, when you're in trial, you get my 100% attention too, and then they get it. They're like, okay, I get that. But
I
it's
use
so
the
hard.
I use the stove example, front burner, back burner. I'll tell them, look, right now you're on the back burner. Naturally, I'll make sure everything gets covered.
Yeah.
But when someday you'll be on the front burner, someone else will be on the back burner.
Sure, yeah.
There's just so many hours a day I have, which is why I have a small caseload.
Very.
So I could devote a lot of attention to each case.
Yep. And you mentioned one thing called costs. So this flat fee covers our time and our staff's time. It's like, but then there's costs, which are, if we have to pay a third party to do something in a case, could be a court reporter, could be a private investigator, that's on top of the fee that the client is paying us, because it doesn't go in our pocket. But the good thing, because a lot of times when they get the costs with my clients, they're like, wow, I have my corporate lawyer, I have my divorce lawyer. The costs are often more than my attorney fees. They're really high. And the good news in criminal, the costs aren't always as high as people expect, because you're being forced to show up in court by the government. You are being criminally prosecuted, and you can't just say, oh, I want to stop doing my divorce because I can't afford it anymore, or I want to drop this corporate litigation because I can't afford it, and actually remove yourself from the system. You cannot remove yourself from the system once you're being prosecuted. So actually the court and the state, the government, federal or state, will often pay a lot of the costs in criminal cases. Not all of them, of course, but the costs are less. My clients always say they're surprised that the costs are less in these cases than they are in their others.
Well, in these big, high-profile, large dollar amount, high volume of document cases, the costs can add up. I've had cases where the government turns over what we call discovery, which is all the evidence that they may choose from to use at trial. Right. And I've had terabytes of discovery, and I have to go, I can't possibly go through every one of them, millions of documents. So we hire companies that actually store them, optically scan them, organize them in a fashion that we can run searches and find information. That's very expensive.
Right.
The other thing that's happening now in trials is, in the old days, I remember when I began as a prosecutor, all your exhibits were pieces of paper.
Right.
Or if they were, physical, tangible exhibits, a gun or whatever. But documents were all in the form of paper, hard copies. You'd introduce them into evidence once the judge accepted them. You'd hand them to the bailiff or the court officer, and the court officer would bring them to the jury to what we call publish them, which meant simply the jury would look at them one by one. Number 12, number 11, hand them down.
Yeah.
In the meantime, you're asking questions. There's always a chance they can lose, hearing what you're saying,
right.
which is a lot of times I try to stop, and judges in the past didn't want me to, because they want to move the case along. Well, that's changed. Now we're in a digital world. And now, in fact, in the new courtrooms that are being built, a lot of the jury boxes have individual screens in front of each juror's chair. And you make your presentation digitally, electronically, and that costs money. You've got to organize it. You've got to have somebody, technician there with the right equipment and trained in how to do it to make these presentations. It can be very, very expensive.
Yes, it can. It can be expensive. But I also want to talk about why it's a flat fee, which you did a great job explaining. There's actually a United States Supreme Court ruling that says it's not mandatory that criminal defense lawyers quote flat fees, but they highly recommend it. And the reason they recommend it is that if you have two similarly situated defendants, let's just use, they both were caught selling. Well, they were both got DUIs, and one happens to be someone who makes $30,000 a year, and the other happens to be, a multi-millionaire. They know that if we bill hourly, we're going to spend more time on the multimillionaire's case billing hourly because they can afford to pay 1,000 hours or even 2,000 hours. They don't care. And we're going to spend less hours on the person who doesn't make much money because they can't afford to pay as many hours.
But I don't think that may be their justification. I personally don't think that's true.
Well, here's what happens, though. If you quote a flat fee for them, whether the poor person, it's a little bit of a flaw in their reasoning at the U.S. Supreme Court. But let's say you quote the $5,000 to the person who doesn't make a lot of living. You quote $100,000 to the person who does make a lot of money. Well, you are obviously getting more money based on the person's wealth, but ethically, under the bar rules, we're required to do just as good of a job and work just as hard for both of them. So we actually wind up quoting different fees, but we're bound by the rules of the Bar Association to put 110% into every case, no matter what fee you charge. So there's a little bit of a flaw in that idea that, you shouldn't bill hourly because you'll spend more hours on someone else's case.
Yeah, and
that's where that comes from, though.
I think, frankly, sometimes these bar rules are out of touch with reality.
That's true.
But don't get me started.
Right.
Why aren't we allowed to charge a contingency fee?
Right.
If we believe we could be successful for our client, why don't we charge a contingency fee?
Right.
Well, the bar rules prohibit that. Obviously, it's an enormous risk.
You're saying like a success fee?
A success fee.
Mm-hmm.
You're not even allowed to charge a success fee.
Right.
So we're basically left with charging either hourly, we can't charge contingency or success, hourly, or flat fee. And as I said, I prefer flat fee. Now, if the client wants to reward us for a fantastic result, they can do that.
Yeah.
But we can't make that a condition of our retention.
Yeah. And most of the time, a lot of times, clients are begging me, save my life, save my life. I can't go to prison. I can't go to prison. This is horrible. I know I'm going to get convicted. I'm going to get convicted. And then when we win the case, they look and say, I shouldn't have been arrested in the first place.
Yeah. Well, here's the interesting reality. The time in federal criminal cases that you can be the most effective for your client is when they first come under investigation.
Right.
That's when a smart client should be willing to pay good fees for your representation, to work hard to try to minimize or get rid of a possible criminal charge.
Right.
That's when you have the most opportunity to do something favorable for your client. Human nature being such, most people don't want to spend the money at that point in time. Then the next step is they get charged with a crime and they're facing a trial. And then you quote them a large fee, and a lot of times they go shopping for a cheaper attorney.
True.
And that, to me, makes no sense. Now, if you don't have the money, you don't have the money. I understand that. But if you have the money you shouldn't be shopping for a cheaper attorney. If you have cancer, you're not shopping for a cheaper surgeon.
Not when you're, yeah, correct.
Okay? So, but then again, the clients sometimes they don't want to spend the money. So originally, when you're under investigation, your slope difficulty is not as great as when you're on trial. The vast majority of federal criminal cases end in convictions.
Right.
Okay? Because by the time they've charged you, they've really worked up their case for 6 months, a year, 2 years, 3 years, 4 years in front of a grand jury. Then, when they're convicted and they've got to appeal, the slope, the degree of difficulty becomes much higher. Vast majority of appeals are not won. But then all of a sudden, they really want to spend money.
Right.
Okay? And then, after they've lost the appeal, and there's virtually very little you can do, now all of a sudden they've got all the money in the world to try to have you perform a miracle.
Yes.
So the smart people spend the money on the outset.
Correct. Up front. You know, there's a conflict that's created by these lawyers, in my opinion, and I'm not going to make any friends here, that's for sure, in the legal community, amongst the lawyers who charge by the hour. Like the flat fee, as I said earlier, you know exactly what you're getting into. I have seen a lot of cases where the civil lawyer is exploiting the hourly billing. And I'll give you an example that comes into our criminal world a lot is I'll have cases, I have one right now actually, it's a pretty serious aggravated battery case. And my client is accused of, hurting someone physically. That victim hired a civil lawyer, and before he got sued, the civil lawyer reached out to me before filing a suit, and we had a great rapport. And I basically had a really good conversation with him, and we were online to settle this case, and civilly, even though I'm the criminal law expert, we were on the same page. We were going to settle the case, and then my client, and by settling the civil claim, they were going to agree to go tell the prosecutor that we don't want this pursued. Now, the prosecutor can still pursue the case, but it would have helped our defense a lot in criminal court. But what happened was when I told the client, the defendant, that I got a call from a civil lawyer, he originally got a letter, actually a demand letter, he called me, the client called me, I then called the lawyer. But he then went on his own and called and hired a civil lawyer who's now billing by the hour. So that civil lawyer calls back after I've already told him I had a great rapport with the victim's attorney, civil attorney. So I got a great rapport. I think we can work this out. He goes and he starts throwing all this stuff at the civil victim's attorney to make it super litigious because he's billing by the hour. And then my ability now to settle this criminal case and actually get him a really good civil settlement as well just went out the window because now the civil victim's attorney thinks, I'm going to start, this guy's coming at me because he was billing hourly, right? And so it really screwed up my whole defense. And that case is still going on, and it's really, really frustrating for me.
That is not uncommon.
No.
I mean, look, lawyers, have deserve to get paid for their time. And there are often many cases where they spend a lot of time on the case, billing hourly, and nothing ultimately advances for the client. That may not be the lawyer's fault.
Right.
It's just the nature. I had a partner once who had a very good saying when he described why he doesn't like to bill hourly. He said, I don't get paid to do things. I get paid to get things done.
Absolutely, right.
And that to me says it all.
Right.
But I wanted to bring up, as part of this discussion about how we charge and why we charge, some examples of how we sometimes make the wrong decision.
Right.
I don't know if you've had those experiences in your past.
Sure. Yeah.
Sometimes clients will offer us, instead of money, because they're cash poor, something of value that they say is equivalent to the amount that we want to charge. And I had a client once who had a Ferrari, so he said, that he wanted to give me as part of a fee. And he had all these incredible photographs of the Ferrari, beautiful photographs, described the car to me in great detail, gave me all the information about the car. And I then went out separately and talked to a number of dealers and a number of people in the car industry to get a good fair market value. I looked online, blah, 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 and I came up with a number. It seemed like the right number, and I said, okay. And I signed a retainer agreement. He signed a retainer agreement. And then he delivered the car to me. Now, how this guy ever thought that after delivering that car to me, I would continue to represent him.
Oh, boy.
It was a fake engine.
Really?
I
Wow.
frankly had never seen anything like that
Wow.
in my life.
Yeah.
He had an engine in there that was, when I say a fake engine, the Ferrari normally came with I think that car had a V8 engine producing 400 and something horsepower. It was a 360, a Ferrari 360 Modena. This was a number of years ago. I opened the hood. He took pictures of the car when it apparently had the
A
V8
real engine in it.
I opened the hood,
Wow.
and there was an inline six.
Oh my God.
You could have put suitcases around it in the hood.
Wow.
That's how much space there was. I was just like shocked. I couldn't believe it. And I said to him, you know what? You can take that car back. And he said, well, but you've already signed on. You began working on the case, federal case. I said, you know what? You defrauded me.
Yeah.
Do you want me to tell the court that you defrauded me? Because I'm prepared to do that.
Yeah.
Okay? And he said, all right, he signed it. You can get out of a case, even if you're not getting paid, if the client consents.
Right. Yeah, it goes back to the guy I talked about earlier who tried to stiff me on an $80,000 trial fee, and you just don't understand, what are they thinking? If anything, they should be bringing us gift certificates and washing our car for us, not ripping us off. It makes no sense.
And then I had another opposite situation where I had a client in federal court in Atlanta. He was accused of drug dealing, narcotics trafficking. I always joked that he was the biggest. I said I represented the biggest drug dealer in America because he was 6'8", and he's a very nice guy. And he had a sailboat that the government seized, and I didn't know anything about sailboats, but it was something called a Norder Swan. And if you know sailboats,
Swan is a great sailboat. I do know
my God.
sailboats.
Anyway, and the government seized it. And at the time, this was years back, I quoted him a fee of $75,000, and he said to me, you know what? I'll make you this deal. I'll pay you $75,000, or if you can get the boat back from the government, you can have the boat. The boat was worth at the time like $400,000. It had the most amazing interior, beautiful captain's cabin, pull-out maps, all teak inside, beautiful boat. And I knew nothing about boats. But I said, for me, that's a big risk. What if I don't get the boat back?
Right.
So I said, nah, I'll take the 75. I'll take behind what's door number one.
Yeah.
I'll take the 75,000. And that was fine. And then at some point, I went to make my efforts to get the boat back, and I figured since there was a forfeiture issue, it was going to take a lot of litigation and a lot of work, but he wanted me to do that. I make one phone call to the U.S. attorney, convince the U.S. attorney to give the boat back.
Oh, no.
It took me about 12 seconds.
Oh, you couldn't go back.
So I made picked the wrong door.
Yeah, you did. You did. That's funny. Well, there's a couple other things I think about, and we have good experience. Most of our clients, certainly, really 99% of them are honorable with us when it comes to our fee. But I keep going back in my mind to this conflict with civil attorneys, so I'm going to talk another moment or two about what I'm going to call bad actors. And there's bad eggs in every field, but most people are good, right? So I've seen clients, friends of mine will call me. They have this corporate lawyer, their divorce lawyer, and like, guy, my bill is out of control. Will you look at it? And I'll, as a favor, look at it, and I'll see that they got billed 3/4 of an hour for a email, and I'll look at the email, and the email will say yes. That's all it says in there. Yes, there was a responding to an email that said, do I have to be at court on Thursday? And it will say yes, and they bill. So you see things like that happen when these guys are billing by the hour. They can take advantage. The other thing I've seen in our world of criminal law is with divorce lawyers. I can identify a handful of divorce lawyers. I've worked with hundreds of divorce lawyers, or I'm familiar with them. A handful of them who their clients always wind up being the victim of domestic battery. I'm like, what a coincidence that these particular lawyers, these 5 lawyers that I see on a regular basis in divorce attorneys, wind up all their clients are always the victim. Which, number one, it's a strategy probably on their divorce case to give them a leg up, some leverage, but they're also billing by the hour, and so they now get to bill more hours to that person. So it's really bad when I see the bad actors like that in these fields. I had one personal experience on a case where I was in a pretty big trial up in Michigan, and I was up there. It was a big enough case. I brought 5 people from my office. We set up a war room. I rented a suite. Everyone had their own hotel rooms. I had a suite with a big family room. We set that family room up like a war room. Everyone would come in there all day. My 5 staff, my client, his wife very often. Sometimes we would excuse her because of attorney-client privilege. And we'd prepare every day for trial. Trial went on for 3 weeks. The government had, I think, 14 witnesses. We had about 6 witnesses. So it's a pretty substantial trial. And we're at the end of the trial. And, again, we were in the courtroom or we were in the war room preparing. And at the end of the trial, we do closing arguments. And now and the day ended, and the judge says, all right, jury will come back in the morning to start deliberating. So we felt good, not great about the trial. I mean, you never really know. You and I have talked about that before. But we get back to our room that night after closing arguments, and the next day we're going to go wait to court, and the jury's going to deliberate. And the wife of my client turns to me and she says, it was a great trial. Your team did a great job. She goes, but it just seemed like every time you guys asked a question or cross-examination, it seemed like they were always one step ahead, the other side. They always seemed to either know what you were going to ask or know the point you were going to try to make on cross-examination. She goes, that was kind of weird to me. She and her husband never been in a criminal trial before. And I said to her, the truth is, just like we're really competent and prepared, I said the government did too. They have very seasoned, experienced lawyers on their side. They prepared all their witnesses. They talked about what kind of questions might come after we might be asking them. So they were prepared just like we were, and it made sense to everybody, and because that's the reality of how this often plays out. So everyone went back to their room that night to go to sleep. We said we'll meet in the lobby and go to court together in the morning and wait for the jury verdict. And I got hungry. It was like literally 10 o'clock at night, and I just worked right through dinner that evening. So I went on the TV for the hotel, and I'm looking on that. How hotels have like their own channel, a proprietary channel.
Right.
It'll tell you like what the amenities are at the hotel, the pool, the gym, maybe some things in the community you can do.
Right.
And as I'm flipping to order room service, because I was hungry, a little late night snack, I flip around and I notice when I'm looking for the room service, I noticed that the proprietor of the hotel was actually one of the victims. This was a white collar case with there were like 10 victims in this case. And it dawned on me at that moment that one of the victims owned the hotel that my entire team was staying in, and that we were every day preparing, talking about
the rooms.
That's exactly what I thought. I said, this is unbelievable. They must have bugged the room, right? So I'm like, well, what am I going to do? Well, now I know I'm in this town in Michigan where it's very powerful, the people that we were going up against that my client allegedly stole all this money from, and I don't trust anyone there now anymore. So I call my private investigator back in Florida, and I say, I need you to hop on a plane tomorrow and come up here to Michigan because I need you to search my room and see if you find any, listening devices and so forth. So like, all right, I'll be up first thing in the morning. So I go to my client. I'm thinking, do I say something or do I not say anything? And I decide strategically, let's see what happens with the verdict. Once the private investigator shows up, then I'll tell them why I had them come up and everything. So I kind of wanted to keep control of the situation. And miraculously, we had a 30-minute verdict. Like, we weren't even sitting in our seats yet the next morning when the verdict came back. Private investigator wasn't even on the plane yet getting up to Michigan from Florida. Verdict came back not guilty. Not guilty. So now this issue is really no longer a concern.
No, what are you going to do? Set aside the not guilty?
Yeah, exactly. But at that point, I called the private investigator. I said, "Hey, cancel your flight. You don't need to come up here." And then I said to well, actually, before, I guess I said to my client, "What do you think? Here's my suspicion right now about your wife's question last night, which was, really interesting." And I picked this up on the TV. And he's like, "You know what? I don't want to mess with this. I just want to get out of this town. We got a not guilty. Why do anything?" And I said, "That's what I agree with. Let's just move on." Yeah, I thought about a bar complaint or an investigation and so forth. But really, at that point, I let my client make the decision.
I mean, frankly, it probably would have been a federal crime.
Yes.
To have eavesdropped on you.
Yeah.
But I understand what you're saying about wanting to get out. I tried a case once in Louisiana, federal court in Louisiana, and Lafayette, Louisiana. And when that verdict came down of not guilty, which was a complete and utter surprise to me and my client, and we had been treated so poorly on that case by everybody, including the local community, that when that verdict came down, it was like the end of my cousin Vinny.
Yeah.
I said, I got to get out of here. If I don't get out of here, I'm never going to leave.
Right.
We literally, not only did we jump out of that courtroom when the judge said to my client, "You're free to go."
Yeah.
Get in the car. We didn't even go to the local. We drove straight to Baton Rouge. And grabbed a flight there and got out of it.
I love it. I get it. I've been in that same boat always.
Yeah.
So often, I've been talking a lot about bad actors, and there's obviously, I've said it, most of the time, 99% of the time, they're good actors. But I do want to kind of, as we wrap up, share a good experience, with the prosecutors. The last one in that case, maybe they weren't so honorable, in the hotel in Michigan. But in this case, I had a really great prosecutor. So I had it was a health insurance fraud case. There were 20 people arrested. For those that don't understand out there listening, basically they were creating fake bills. So if someone came in for medical treatment, the doctors were billing 6 things when they only got 1 or 2 treatments, right? They were extra overbilling for things, and they all got caught. This group there was a conspiracy, and they were getting prosecuted, and so but the government didn't have a really, really strong case. They had some weaknesses, some concerns with their case. So every defendant, all the 20 defendants or so, were reaching out to prosecutors saying, "Hey, all the lawyers were saying, 'Hey, let me bring my client in. You need they'll be your witness. Let me flip my client. He'll testify. You cut him loose or give him a really good deal.'" So this prosecutor, because he realized he did have a weak case, he met with, I think, every one of the 20 defendants. And when we met with my defendant, he was very honest with him at the beginning of the meeting. He said, "We're meeting with you, but there's no guarantee. In fact, we're very unlikely to give you any type of deal. We're unlikely to use you as our witness and prosecute the others instead of prosecuting you, because you have a very long criminal record. None of the other defendants have ever been in trouble before, so they have great credibility in your case. In this case, so as we sit here today, I want you to be clear. You're here to proffer, which is to talk about the case with us, and we'll decide. But I highly doubt we're going to give you any type of a cooperation agreement and cut you a deal." And so as the prosecutor, I was with my client, just me and my client. There was a prosecutor, and he had 6 federal agents there with him. So we were definitely outnumbered. They were definitely teaming up against us. And the prosecutor started by saying, "Mr. So-and-so, why don't you just give us a little bit of your background, age, where you grew up, your education." So my client goes through all of that, and, very formal, very polite. My client was a real gentleman, actually, and so at the end of saying, where his date of birth and this and that, and how many kids he had in his marriage and this, that, the prosecutor, we call him AUSA, he's Assistant U.S. Attorney. He turns, and when he's finished with kind of giving his background, the prosecutor says, "By any chance, are you connected to the family that owns that very large chain of Italian restaurants?" My client says, "Yes, absolutely. That actually is my family." He said, what's your connection to the restaurant? Because you didn't mention that in your background. He said, well, I worked there since I was 6 years old. And about 7 years ago, after 25 years of working in the family business or so, I got into drugs, and it got so bad that they kind of threw me out of the business, and I got a drug conviction, and that's what kind of led me to get into this mess, because I can't really make a living anymore with my felony conviction for drug trafficking, and I was doing this thing, which was obviously wrong. He said, so I've been thrown out of the business for 7 years, but yeah, that is my family business, and I know it inside and out after 25 years working in there. The AUSA then spent the next, I'm not lying, 2 hours talking to my client about how you make a great pizza, how you make a good lasagna, the differences in cheeses and temperatures and waters and just everything. Literally 2 hours. All the agents in the room, I think there were 6 of them in the room, didn't say a peep. They were just sitting there. No one's taking any notes, which you usually see during these proffers. Everyone's scribbling away. Yeah, no one's writing recipes. But this prosecutor, this federal prosecutor, who was actually a really seasoned guy, he had been there many, many years. He was much more experienced than I was. He had such a good time talking with this guy, learning all these secrets to how you make a great pizza and a great Italian dish. And he never once asked him about the case, not once about any evidence, not once about what he saw or witnessed or any of the other defendants in the case whatsoever. And then he basically turned to everybody and says, I think we're going to use him as our key witness in this case. Right? I love saying that you just can't make this shit up, right?
Oh,
so this
God.
is real life story.
Imagine in front of the jury,
By the way, all the other, right, because he had, I'm telling you, a really long criminal record from those years he got into drugs. And every other defense attorney, all 19 of them, because I think there were 20 defendants, they all came to me. They said, our client is so pissed off at me, not me, them. Their clients are pissed off at their lawyers because they deserve to be the witness that the government used. And they're like, how the hell did you get them to, your client's the only one with a criminal record.
You got to make a good pizza.
Yeah. And I never, believe me, but trust me, I never told any of these other lawyers how I got the deal I got, because I didn't really get it.
Wow.
My client got it. But they were all furious. Every one of the other defendants, how the heck? And they would see me at the court.
It's interesting, but every once in a while, the whole human experience comes into play.
Right.
And just people connect, you
connect.
And connect. And sometimes that happens. Often it's the opposite. Usually when you walk into a session, what we call a proffer session with the government, they already have a completely set in cement feeling and notion or attitude about your client.
Yeah.
And so sometimes it takes a pizza to change that.
Yeah, exactly. He really liked them.
That's a fabulous
story. A good actor,
well,
not a bad actor.
This has been great. And I think from time to time we should do more of answering the questions that our listeners have. Yeah. And we sprinkle in our own experiences, our crazy-ass cases, along with trying to educate them and explain how things really work behind the curtain.
Right. Yeah, I agree. And I'm just enjoying that we have so many listeners out there that we're starting to get questions. The first 10 or 15 episodes, we didn't even know if anyone was listening.
Right. Now, anybody out there?
Yeah. Now, I don't know if I said this as we wrap up, but I was at a restaurant recently with a few couples and my wife, and the waiter came over and said, at the end, about dessert. I don't know if I've mentioned this online here.
I think you did.
Did I?
Go ahead, tell us.
And he said, what would you all like for dessert? Well, we're going to pass on dessert. He said, well, if you were going to order dessert, what would you like? And we said, the chocolate cake. And when he came back, he said, it's on me. I'm a big fan of the show. Right? So it's just getting out there.
Well, I'm going to go have pizza tonight, so maybe I'll get a free
and some
pizza.
Chocolate cake.
And some chocolate cake.
But until next time, everybody.
Next time, please, you're
free to go. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fromston and Mark Nurek and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.